Hi, friends. Welcome. Audit could be a very risky activity. It's not for everyone to do it. Okay, those who have been the best auditors are those who have the passion for it and who stand for all the principles of proper auditing. So auditing has its own liabilities. Okay, that's why as an accountant or as a chartered accountant, we are always being seen as working for the public interest. Now, as an auditor, you are also working for the public interest, yes, and also working for the shareholders' interest as well. So if you don't do your work well as an auditor, you could be in hot waters. Today, you may have read in the stories where the big four audit firms, almost all the big four, KPMG, EY, PwC, Deloitte, have had some form of sanctions due to their negligence or not undertaking proper training or proper care, what we term professional competency and due care in their work. Audit has its principles that we use. Let me say ethical code of conduct, which governs our profession. One of the professional codes, ethical codes, which I love so much, is the professional competence and due care. To me, I think it cuts across all the other principles or ethical codes. For example, if you lack integrity, what makes you a professional? If you're not confidential to keep the client's information confidential, what makes you professional? Okay, so the professional competency and due care is a very key ethical code, which has a lot. If we're able to apply it to the letter, then auditors will end up being immune from their audit liability or auditor's liability. So we're looking at auditor's liability. What does it mean? Like I've just explained, auditor's liability deals with the situation where there could be a potential liability hanging on the necks of the audit firm if they don't apply professional competency and due care in their work. An example, a company like Arthur Andersen, if not for what happened, I think Arthur Andersen could by now become one of the big four. Okay, but you know the scandals that happened to them. All right, what are we looking at here? Look at the auditor's duties under the Competence Act of 2006 regarding their reports. We will try to understand the requirements of contract law, criminal law, case law, and how we can perform our work as auditors, where we can exercise reasonable skills and care. And then we'll look at the term proximity or proximate. And we discuss the question of auditors' liability to third parties for their negligence, for the auditor's negligence, okay? Negligence is not allowed. If you do it, I mean, you could be held liable for any cost incurred by third parties. Then again, we look at how audit firms could minimize their liabilities to third parties. So auditors have a duty of care. Okay, under our code of ethics, we have duty of care to exercise based on our terms of engagement terms of engagement, and also as a result of our professional act. Okay, our duties. Now, if you look at Companies Act 2006, they've stated some offenses that could arise or that could accrue to an audit firm if they don't exercise judgment. For example, one, if the audit firm accepts to be an auditor when they know they are not qualified or they've been disqualified to continue, it is an offense. They could incur liabilities, okay? If they conspire with others, if the auditors conspire with others within the company to falsify accounts and to present false accounts, it happens. It happens. It is also an offense. And again, if they knowingly or recklessly conduct an audit, report it, when in fact they know that the content of the information presented is misleading, is false and deceptive in a material way that could affect somebody's judgment, it's also an offense under the Companies Act, okay? So auditors must do their work to the best of their capability. That's why as auditors or as a chartered accountant, the professional body, supervisory bodies, for example, I'm a fellow with the ACCA. every year I'm required to at least meet 40 CPD credit hours. Otherwise, you will not be in good standing, okay? So we must do our work to the best of our ability. Negligence is not allowed in the work. Negligence is never allowed, okay? Now we must be up to date and professionally competent. That's why, like I said, ACCA would always require you to have 40 CPD hours every year to comply, else you will not be in good standing. Okay. Now, as I said, negligence, never allowed. If you are negligent in your duty, what will happen is that you could be prosecuted by the client itself, by potential third parties who rely on your report. Okay. So as auditors, we are employed under the terms of contract, letter of engagement, and we have a duty of care. Okay. When we talk of duty of care, it means that the auditor has the obligation to exercise the highest level of care, must be reasonable in all his activities when carrying out his professional work. Okay. So it requires reasonable consideration of possible consequences that could occur to somebody who relies on your report. Okay. Now, for a negligence to occur, the claimant, the one who is prosecuting you, who is prosecuting the auditor, must prove that the defendant had a duty of care to the claimant. Okay. Auditor has a duty of care to the one who is reporting you to the plaintiff. Okay. There must also be a proof that there was a breach of the duty of care by the auditor, which has caused harm or damage to the person who is taking you to court. That the damage must have been foreseeable. The auditor must have foreseen that if this guy relies on my report, and I know he will rely on my report, then I am liable for whatever has happened to him, okay? And there must be what we call the proximity between the parties. Okay, proximity, I'll explain further. So simply, which of these stakeholders is a neighbor? Neighbor, as in the word neighbor, who rely on your report. If, for example, I have done my work and there's a potential investor who would have relied on my report, potential, I don't know him. I don't know he will rely on my report. Then that guy is actually not proximate to the report, to the situation at hand. But if I know of a shareholder and I know he rely on my report to take a decision, that guy, there's proximity between myself and that person. Okay, so that's proximity. Now, again, there must be a proof that it is fair, just, and reasonable for the court to impose a liability on the auditors. There's a popular case that I want us to look at, okay? The Kingston Cotton Mill guidelines. What happened under Kingston Cotton Mill is still considered the issue of reasonable care or duty of care. And it tells us that, listen, auditors are not, we are watchdogs. We are not a bloodhound. Now, let me tell you something about it. Kingston Cotton Mill. It happened in 1896. Now, it was held during this report, okay, that auditors, of course, we are watchdogs. We are not bloodhound. Now, it tells us that the judge who passed the judgment in 1896, Justice Lopes, said it is the duty of the auditor to bring to bear on the work that he has to perform. The skills that he has, he must bring to bear his skills, his care, his caution, which a competent, reasonable, competent, careful person could rely on, okay? So auditors must be very reasonable, competent, cautious, and then careful, because somebody could rely on us. That's the duty we owe as an auditor. And we should know that somebody could competently rely, carefully rely on what we are presenting. Now, in this particular case, we are being told, listen, we are not detectives. Auditor is not a detective, okay? As our approach is, we are not supposed to approach the work with suspicion. Go into the client's office, you already have a preconceived idea that there's a fraud here. I'm going to watch, look, no. Then you are becoming a bloodhound. You know what a bloodhound does? Those big dogs who are used for hunting, they sniff, they search for prey that they can predate upon. We are not bloodhound. We are not going there with a preconceived idea that there's something wrong. We have to look for it, okay? So we should be very careful not to go in with that mindset, okay? We should have that duty of care, that special relationship between us as auditors, to our clients, and even to third parties, to the extent that we'll do our work with the best of our ability, because somebody will rely on our work, or a group of people will rely on our work, okay? Any party who takes or who imposes a liability or wants to take the auditor to court must prove that the auditor knew, or the auditor should have known, that he, the one who has been injured, was likely going to rely on the report. To look at some cases, okay? Again, the person must prove that the injured party has sufficient proximity. Like I said, it belongs to a class that will likely rely on the financial statement. People we know will rely on the financial statements. And again, this party must prove that the injured party actually did rely on the report of the auditors, and that the injured party would have acted differently if the reports had shown a different picture. So this is what we have to prove, okay? So let's take one or two case studies. There's a case law, okay? There's a case law, and the Kingston Cotton Mill, like I mentioned, it reinforced one particular case, the London and General Bank situation. I wouldn't go much into that, but like I'm saying, what they told us, what it all stated was that we are to go in, yes, with professional skepticism, but not with a suspicion or preconceived idea that there's something we are going to look out for, okay? Now, we should not, they said auditors must not be made liable for not tracking. Listen, auditors may not be held, doesn't mean, they said must not, but currently it looks like may not be held liable for not tracking down, okay, any ingenious and carefully laid out schemes of fraud when there's nothing to raise that suspicion. So what happened was that the Kingston Cotton Mill case made people relaxed. Auditors going, this is what I've been given, this is what I will do, no other work. And it impaired their work. It actually questioned the quality of work auditors were doing. But currently, we have the ISA 240, okay, International Standards on Auditing 240, which talks of the auditor's responsibilities relating to fraud in the financial statement. What it's telling us is that we shouldn't just accept it as given. We should approach our work with professional skepticism. Take a lens, take a critical look at the work, examine it, where you think you have to. We don't want to use the word suspicion, but in fact, in a layman's language, it would be like suspicion. Any document given to you, do not just accept it as given. Go beyond, think outside the box and look at it. Okay. An example of a case which happened, Thomas Girard and Son in 1986. You know what happened? The CEO of the company falsified inventory figures and even falsified invoices. At the end of the day, what the CEO was doing with that, he was trying to cook the books to make it look so nice. Where there are losses, he covers it so that we can get dividends and pay to the shareholders. In reality, there were inventories which did not exist, okay? And he had to change the invoices. These invoices, falsified invoices, were given to the auditors. They looked at it, but they did not investigate it. They saw it, they suspected something, but they did not follow up, okay? The auditors came out by saying, well, we relied on the inventory certificates given to us by the CEO, and we trust him. This is somebody who have been placed in a position of trust, okay? So the auditors were saying, well, we trust him, so we have to use it, okay? Now, they contended it was not part of the auditor's role to count inventory. Merely they have to verify the figures, and that they were entitled to rely on the assurances given by this CEO, responsible official. And so they cited the Kingston Cotton Mill scenario. We are watchdogs, we are not bloodhounds. And that's what they stated, okay? But however, do you know what happened? They were held liable, okay? They were held liable because in this case, they were told that, listen, you guys should have gone the extra mile. You should have gone the extra mile because once you've seen evidence of some falsified papers, you should have gone the extra mile, okay? So a lot of things are now happening. Once you've discovered falsified inventories and documents, you should actually go further. Don't rely on directors' So auditors were held as negligent. They breached their duty of care. Now, there's a typical scenario, liability to third parties. Caparo Industries and then Dickman. This is a very popular case law that I think we have to look at. Again, before we go to the Caparo Industries, there was also in 1951 this case of Candela versus Crane Christmas and Co. Now, Candela was a third party to the company, and he sued the auditors, the accountants, Crane Christmas, because Candela, relied on the accounts that these accountants, auditors had prepared for the company. And based on the report that Crane Christmas had prepared, Candela relied on it and invested in the company. It turned out that the accounts which had been prepared were actually wrong, totally wrong. So this guy lost his investment. So he sued. But you know what happened? They ruled that the accountant had acted negligently. That's true. He didn't do his work well. But accountant didn't have a contract with Candela. He had a contract based on his terms of engagement with the company. Therefore, he had not breached any duty of care. Okay. So the accounting profession took this, that no duty of care was owed to third parties. Now, listen, it was because of proximity. Candela was not too close to the auditors. The auditors may not have known that Candela will rely on the reports. That's why. Now, the popular case I was talking about, Caparo Industries and Dickman, okay? Very important case, we want to all look at it. Now, it happened somewhere in 1989, okay? But it started somewhere in 1984. Now, Caparo was a minority shareholder of a company called Fidelity PLC. Caparo actually waited, these books were audited by Touche. Let me go to the next page. Okay. It was audited by Touche Ross. Some people will say Touche Ross. Okay. Now, what happened here was that before the takeover, the Caparo actually ended up taking over Fidelity. Before the takeover bid, Caparo was a minority shareholder. The accounts gave a very good position of Fidelity when the auditors did the work. And so eventually, Caparo took over the Fidelity company. He was a minority. He became a majority shareholder. But later, when he took over, he realized that, no, the books were false. They were terrible. They were wrong. Okay, so he sued the auditors. The auditors owed a duty of care to them. Okay. Now, do you know what the court initially, they found it in favor of Caparo in 1989. So that's why the date 1989 was cited there. Initially, it was found in favor of Caparo, but on appeal, the House of Lords overturned the case. You know why they overturned the case? So initially it was in favor of Caparo, but later they overturned it because the judgment held that there was no proximity. Now, though they were minority shareholders, auditors will know minority shareholders will rely on the reports for their dividends or share of investment in terms of revenue earnings on their stocks. But the auditors did not know that these guys will become potential majority shareholders, or they will take over the company. They would have taken over. They will buy the company, okay? So it was held that the auditors' role, yes, they must be aware of existence of third parties. They must know whether these guys will rely on their account. They didn't know Caparo was going to be a majority shareholder and he was going to rely on the accounts, which was prepared, okay? So our role as auditors, yes, we must protect the company from errors, not its owners, okay? And we are to provide shareholders with information so that they can scrutinize the conduct of directors. But auditors, our role is not to aid in investment decisions. Okay, there's another beautiful case by Peach Properties. Okay, you can look at it in the text. Okay, then there is also a popular case, ADT. So ADT's case is also similar. Okay, what happened in ADT versus a company? So ADT, the audit firm is called BDO Binder Hamlin Audit. Now, ADT purchased Britannica Securities Group for 105. when in reality, the net assets was worth 40 million. So during negotiations, the audit firm had a meeting with ADT and confirmed that, yes, they stood by their audited accounts. Can you imagine? Auditors said they stood by their audited accounts. Now, there was a relationship between ADT and the auditor, because the auditor actually engaged ADT and told them about their report. So they knew these guys were proximate to the accounts. So they owed a duty of care to ADT. Yeah, they did not. So therefore, they awarded damages of 40 million against the audit firm, and they paid. Okay. I cited an example recently about Grant Thornton. I will not go into that case. Okay. Now, another popular scenario or case study has to do with the Royal Bank of Scotland versus Bannerman Johnston Macleay. Okay, so simply let's say Bannerman. It was just recent, 2002, maybe long ago. Okay. Now, what happened here was that the defendants were auditors of the company. Okay, so BGM, Bannerman, let's say Bannerman. They were auditors of a company in 1998. The company went into receiverships with debts of about 13 million being owed to Royal Bank of Scotland. Now, Royal Bank of Scotland claimed that due to fraud, the accounts of the previous year had misstated the true financial position of the company, and the defendants, the auditors, Bannerman, were negligent in actually disclosing this. What was happening was that Royal Bank of Scotland was the major lender to this company in question. And the auditors knew that the Royal Bank of Scotland was rely on their accounts to take decisions. Okay, so auditors claimed they had no duty of care as they didn't know the bank was relying on their accounts. Okay, but it was held that auditors actually were aware of the arrangements. They knew because there was like monthly management accounts which are supposed to be sent to the bank, and then periodic annual accounts which were supposed to be given to the Royal Bank of Scotland because of this particular client. So they dismissed the case of the auditors. Auditors were held liable and they were dealt with or punished. Today, what happens is that because of this proximity, auditors are now putting some kind of disclaimer statements in their results, in their reports, so that it will appear reasonable. What is happening is that if you don't take care with this disclaimer statement, auditors will always be doing shoddy jobs. Okay, so proximity was established even if the auditors had no actual knowledge of the use of the accounts were put to. Now, like I said, disclaimer wording is now occurring every now and then. There was another scenario, Barclays Bank versus Grant Thornton. Now, in the same scenario like the Royal Bank of Scotland scenario, what happened with the Barclays Bank scenario was that Grant Thornton were auditors to a hotel, Van Essen Hotels Limited. Now, they were tasked with preparing non-statutory audit reports. Grant Thornton would prepare these books, and he knew that these books were being looked at by Barclays Bank. They will prepare normally with the quarterly reports and these non-statutory audit reports. Now, the company, Van Essen Hotels, went into liquidation. Okay, and it was discovered that the financial director of Van Essen was falsifying accounts, preparing fake accounts, and these auditors Grant Thornton could not identify it. So Barclays sued Grant Thornton. Now, what do you think would have happened? In the auditors' reports or whatever summary reports that they write and present to auditors, they always put a disclaimer statement there. They clearly stated there, 2-page report. Barclays Bank refused or they did not take the pains to read those 2 reports. They go straight to the financials. So that alone gave some kind of immunity to the audit firm. So Grant Thornton got themselves free. They went out, so they were not fined. They couldn't bear any cost over there. So I mean, they held that a whole company like Barclays Bank should have had the judgment, taking the steps to at least read those 2 pages, and they did not. They did not. Okay. So disclaimer statements are now being issued by firms to ensure that they get themselves out of this mess. And like I said, if companies, audit firms continue to issue these disclaimer statements, what will happen is that study work will be done. Okay. So these disclaimers is going on. Everybody wants to take a shield to prevent any cost. Okay. So auditors have a duty of care when they know that somebody will rely on their reports. And since the Bannerman scenario, BGM scenario with RSB, these disclaimer statements are always being issued. ACCA is thinking it's not appropriate because it will devalue the audit report. If I take your report and I realize that all of a sudden you are putting a disclaimer statement, if care is not taken, I will assume you've not done a good job. That's why you're already putting an indemnity clause in your statement, okay? Now, statutory responsibilities cannot be disclaimed. That we should know. How do I minimize the risk, potential liabilities to the audit firm? There are a lot. This is not all. This is just a summary of them, but there are a lot. So the key ones we are seeing that, listen, observe client acceptance procedures. Screen clients. Those you think are risky, don't accept them. Okay, review their existing portfolios. Okay, the existing clients. If somebody just left this particular audit client, if an auditor left this audit client, ask yourself why. Engage. Why did they not proceed with this guy's work? Your engagement letter should clearly explain your role as auditor, okay? And also spell out the role of the auditors and the directors of the company, okay? Perform your work as best as you can properly, use documents, document them, okay? Review the processes. Today, in every audit firm, especially the Big Four, there is always the quality control partner who would ensure that we are on track. We are not doing some crazy, poor job, okay? Where you are in a mess, you are in a fix, seek legal advice. The lawyers are there. That's their profession. They will advise us. Use disclaimers where applicable in your audit report. And then, of course, take some insurance cover with insurance firms on professional indemnity insurance so that if anything goes wrong, the insurance company will bear the risk. Remember when we did the TARA model? So if you think the risk is too high, probability of occurring is high, probability of it, impact of it occurring is high, avoid it. Avoid it. Okay, where you can transfer because probability is low, but the impact is high, transfer it to a risk insurance company, okay? Agree with the company to limit liability in respect of their audit in line with the Companies Act 2006 and use a limited liability partnership. Today, you see most audit firms having LLP, KPMG LLP, because they have limited liability partnerships. Any risk that occurs will bear the cost in line or commensurate in proportion to our shareholdings as partners. So like I said, take a PII so that when you are sued, the insurance company can take care of that. Now, it is mandatory for firms to have a PII. Recently, it is mandatory. Advantage, insurance against risk. It could prevent bankruptcy of the audit firms. So today, KPMG, PwC, the Big Four, name them. You hear them being sued for millions and millions and millions of dollars and pounds. Yet they are surviving. They take PIIs so that the insurance company will bear those risks, okay? What are the disadvantages? It can create ill-founded claims, could be expensive. Okay, insurers could cover accountants' mistakes, and they may also not agree with compulsion. Okay, so those are some of the things. Limited liability by company. Under the Companies Act, we have been told that, listen, auditors can agree to a cap on any claims with the clients. They can agree, okay? And any agreement which they agree should be approved by the shareholders. It could be a specific sum of claim, multiple of audit fees, or a proportionate liability. So go into this agreement. It makes life flexible. We all know that, listen, we are not perfect. We cannot make mistakes. Like I said, audit firms will now go for LLPs so that in case of any risk, we'll all bear it in proportion of in line or in accordance with the proportion of shareholdings that we hold in the partnerships, okay? The main disadvantage of incorporation on LLP status is the disclosure of information and requirements to file accounts. Okay, I'm ending it. One key feature of LLP, it becomes a corporate body, like PLC, okay? Becomes, or LTD, becomes a corporate body, separate legal entity. So distinct from the members, so that the members will not have their images tarnished should any of these occur. LLP does not have any restrictions on its activities, and LLP has members, but does not have directors or shareholders, nor does it have share capital. So the firm will bear the cost, okay? And of course, in proportion to the liability proportions held by the partners. At the end of the day, partners, and that's what I know if situations have changed. Partners file their accounts separately to the HMRC to be taxed. Okay, so in either way, you are somehow affected if the company as a whole incurs a certain liability. It could be apportioned towards to your proportion of profit from the partnership operations. Okay, friends, we wrap up. 2 case studies, very interesting ones. Case study 1, you find on page 477, Fish and Scape Auditors with AHM Publishing. Try that one, and then Zong and Dance Auditors and Daffodil Limited. Self-testing questions, you find them on the same page. Answers are in the core text. All right. So auditor liabilities is real. It happens. And I remember when I was with KPMG, I will not mention the name of the client. We went to audit a client. My partner came, sat down. I was working on other assets, other liabilities, quite a risky area to work. My partner told me, listen, Richard, this area you are working on is the most dangerous of all the accounts captions or classes of accounts we are auditing. Because every other part of the financial statement is within other assets, other liabilities. You are going to find expenses, revenue, asset, liabilities, name them, interest. You find everything in where I'm working. So I'm actually like working on every other person's audit area. And this is what she told me. If any mess occurs and we are taken to court because you don't do a proper job, I'll sack you personally. It did not shake me. It did not make me fear. It actually made me do my work more. So I go the extra mile. I have to document. At the end of the day, they called me head teacher. Head teacher because they said I write a lot of preambles, a lot of justifications before I draw conclusions. Okay. Audit liability is real. Friends, those of you who go into audit, be careful you don't become the subject or the main person who has caused the company who has caused the audit firm to be in liability. Do your work professionally, update your technical know-how, ask questions, learn from those who have been there, consult, speak to the partners, the senior guys. Don't feel shy. Don't think you are the hero. You know everything. We don't know everything. It's only God who knows everything. Ask, document, and be professional. Bye for now.